learning outcomes. After studying this module, you will be able to understand the term constitution and its importance in governing a country, the history of the Indian constitution, the era before independence and making of the Constitution of India. Comprehend the different Indian Council acts on basis for development of Indian constitution. Know about the preamble to the Constitution of India and its significance. Now the introduction. Almost everything we do is governed by some set of rules. For example, there are rules for games like soccer, for social clubs and for adults in the workplace. There are also rules imposed by morality and custom that play an important role in telling us what we should and should not do. For example, in the game of soccer, a referee has full authority to enforce the rules or law of the game on the players. When a player does something against the rule, the referee takes action like send off a player, etc. Similarly, some rules that are made by the legislatures, Lok Sabha, Rajya Sabha or Vidhan Sabha for country or state are called laws. We need laws in society so that our society can regulate the conduct of members of society. They are designed to protect us and our property and to ensure that everyone in society behaves the way that the community expects them to. These laws tell us what to expect as a consequence of our actions. They have been like the adhesive glue that has kept society together. Without laws, there would be a state of complete anarchy. Now, what is the importance of Constitution? The Constitution is the supreme legal document of the land. All other laws have to conform to the Constitution. It contains laws concerning the government and its relations with the people. A constitution is concerned with two main aspects: the relation between the different levels of government and between the government and the citizens. The document containing laws and rules which determine and describe the form of the government, the relationship between the citizens and the government is called a constitution. The constitution, for proper understanding, is divided into broad areas of fundamental rights, directive principles, executive and state. The main object is contained in the preamble and each area, state above relate to the whole system of governance through state, that is legislature, executive and judiciary, called as Trimurti of the nation. Importance: we need a constitution to govern a country properly. The constitution defines the nature of political system of a country. Sometimes we feel strongly about an issue that might go against our larger interests, and the constitution helps us guard against this. All the three establishments of the government, that is executive, legislature, judiciary, functions within the constitution. The constitution stands as a guarantor for upholding fundamental rights of its citizens. It imposes certain obligation or stale and asks to fulfill those and directive principles. It works as a system of checks and balanced between different government agencies. Now, the history of Indian Constitution. India is a home of ancient Indus Valley civilization, which goes back to 3300 to 1300 BC. Mature period is between 2600 to 1900 BC. India is world famous for its ancient history and culture. The time before 500 AD is widely accepted as the era of ancient India. The earliest anatomically modern human remains found in South Asia date from approximately 30,000 years ago, whereas with this regard to constitutional history, India goes back to only 3rd century BC, that is 269 BC to 231 BC, in the time of the Emperor Ashoka the Great. Some of the edicts of Ashoka. The edicts of Ashoka between 324 BC to 185 BC established constitutional principles for the 3rd century BC Maurya king's rule in ancient India. They are a collection of 33 inscriptions on the pillars of Ashoka, as well as boulders and cave walls made by the Emperor Ashoka of the Maurya dynasty. Now, constitutional history or the Indian constitutional history. It dates back from 1324 BC to 185 BC. It was the tenure of Emperor Ashoka. Emperor Ashoka of Maurya dynasty established constitutional principles, engraved them in major rocks, pillars and minor rocks for public to take reference, also known as edicts of Ashoka. Second phases of East India Company from 1599 AD to 1765 AD. East India Company takes total administrative control by gaining right of taxation in Bengal after Battle of Plassey in 1757. Then third phase came from 1765 AD to 1858 AD. It was again of East India Company. East India Company takes total unified control over the whole of India from a single center in Calcutta, but its rule ended with the revolt of 1857. Fourth phase is from 1858 AD to 1947 AD. This period of the British Raj was the time when the Constitution of India took shape. Then the present scenario after 1950 AD. Finally, Constitution of India, created in independent India by its own free people, was adopted on 26 November 1949 and came into effect on January 1950 as we know it and use it today. Now, we will start with the East India Company tenure. In 1600, the East India Company came to India as a trading company from Britain, that is UK. In 1765, it became an administrative power after gaining the right of taxation in Bengal. It defeated the Nawab of Bengal at the Battle of Plassey in 1757. To regulate control over India and Indian population, series of enactments were made by British government which ultimately laid the foundation of Indian Constitution. Then came the Indian Council Acts of 1861, of 1892 and 1909. First, Indian Councils Act 1861. Indian Councils Act 1861 enacted by the Parliament of the United Kingdom that transformed the Viceroy of India's Executive Council into a cabinet run on the portfolio system. As a result of Indian demands, the sizes of the executive and legislative councils were increased. More Indians were appointed to these councils and the principle of election was introduced. This cabinet had 6 ordinary members who each took charge for a separate department in Calcutta's government, home, revenue, military, law, finance, and after 1874 also public works. India Councils Act 1861 is an essential landmark in the constitutional and political history of India. The 1861 Act restored the legislative power taken away by the Charter Act of 1833. The Legislative Council at Calcutta was given extensive authority to pass laws for British India as a whole, with the legislative councils at Bombay and Madras were given the power to make laws for the peace and good government of their respective presidencies. The Governor General was given the power to create new provinces for legislative purposes. He also could appoint lieutenant governors for the same. Indians were involved with lawmaking process. For this purpose, Viceroy nominated the Raja of Banaras, the Maharaja of Patiala and Sardankar Rao. Decentralization of legislative powers took place. The establishment of recent legislative councils in Bengal, North-West Frontier Punjab and Punjab in 1862, 1866 and 1897 happened respectively. It empowered the Viceroy to issue ordinances with no concurrence of the Legislative Council throughout an emergency. The life of such an ordinance was 6 months. Now next is Indian Councils Act of 1892, enacted due to the demand of the Indian National Congress to expand Legislative Council. The number of non-official members was increased both in central and provincial legislative councils. This act increased the sizes of the councils again and also gave the Legislative Council the power to discuss certain matters and to ask questions. More people were elected to the councils. The non-official members of Indian legislative councils were henceforth to be nominated by Bengal Chamber of Commerce and Provincial Legislative Council. In 1892, the council consisted of 24 members, only 5 were Indians. Next is Indian Councils Act 1909. Indian Councils Act 1909, commonly known as Morley-Minto Reforms, was an act of the Parliament of the United Kingdom that brought about a limited increase in the involvement of Indians in the governance of British India. It effectively allowed the election of Indians to the various legislative councils in India for the first time, though previously some Indians had been appointed to legislative councils. The introduction of the electoral principle laid the groundwork for a parliamentary system, even though this was not contrary to the intent of Morley. Muslims had expressed serious concern that the post-electoral system like that of Britain would leave them permanently subject to Hindu majority rule. The Act of 1909 stipulated as demanded by the Muslim leadership. Then came Government of India Act 1919. After World War I, the British government opened the door for Indians to public office and employment. Relaxation of central treatments for the provinces by demarcating and separating the central and provincial subjects. It further divided the provincial subjects into 2 parts. Transferred those have been administered by governor by the help of ministers who are responsible to legislative council, and reserved those who have been administered by the governor and the executive council without being responsible towards the legislative council. Then came the introduction of diarchy, bicameralism, direct elections and establishment of Central Public Service Commission in 1926. franchisee was granted to some limited people on foundation of property, tax and education. Separation of central budget from provisional budget was also done. Then also was the appointment of statutory commission. Then came the Government of India Act of 1935. The provisions of the Government of India Act 1935, though never implemented fully, had a great impact on the Constitution of India. Many key features of the Constitution are directly taken from this Act. The Act can be said to be the foundation of Indian Constitution. The majority of the today's Constitution has drawn from this Government of India Act of 1935. Its features are: it delivers to the establishment of an All India Federation. The previous names transferred and reserved subjects are changed as federal and provincial lists, and concurrent list is definitely an addendum. Abolished of diarchy and introduced provincial autonomy. Abolished of councilatia. Then is established of RBI, federal court, provincial PSUs and joint PSUs. It also extended bicameralism, communal representation and franchisee. The federal structure of government, provincial autonomy, bicameral central legislature consisting of a federal assembly and council of states, and the separation of legislative powers between the center and states are some of the provisions of the Act which are present in the Constitution of India. Now it is Indian Independence Act of 1947. The legislation was formulated by the government of Prime Minister Clement Attlee and the Governor General of India, Lord Mountbatten, after representatives of the Indian National Congress, the Muslim League and the Sikh community came to an agreement with the Viceroy of India, Lord Mountbatten of Burma, on what has come to be known as the 3rd June Plan or Mountbatten Plan. The Prime Minister of the United Kingdom announced on 20th February 1947 that British government would grant full self-government to British India by June 1948 at the latest. Partition of India and Pakistan. The future of princely states would be decided after the date of final transfer is decided. Empowering the constitution for the nations. Now on 18th July 1947, British India divided into two new independent states, India and Pakistan, which were to be dominions under the Commonwealth of Nations until they had each finished drafting and enacted a new constitution. The Constituent Assembly was divided into two for the separate states, with each new assembly having sovereign powers transferred to it for the respected dominion. The Act also terminated British suzerainty over the princely states, each of which was left to decide whether to accede to one or the other of the new dominions or to continue as independent states in their own right. Now the present Constitution of India. Constitution of India 1950. The Constitution was enacted by the Constituent Assembly on 26 November 1949 and came into effect on 26 January 1950. The date 26 January was chosen to commemorate the Purna Swaraj Declaration of Independence of 1930. Dr. Bhim Rao Ramji Ambedkar became the chairman of the drafting committee of the Indian Constitution. With its adoption, the Union of India officially became the modern and contemporary Republic of India and it replaced the Government of India Act of 1935 as the country's fundamental governing document. Conscious efforts were made to have consensus on different issues and principles and thereby avoid disagreement. The consensus came in the form of the Objectives Resolution moved by Jawaharlal Nehru in the Constituent Assembly on December 17, 1946, which was almost unanimously adopted on January 22, 1947. The Constituent Assembly consisted of 385 members, of which 292 were elected by the elected members of the provincial legislative assemblies, while 93 members were nominated by the princely states. To these were to be added a representative each from the 4 chief commissioners provinces of Delhi, Ajmer, Marwar, Coorg and British Baluchistan. For the time being, till the constitution was made, India was governed in accordance with the Government of India Act of 1935. The assembly met in sessions open to the public for 166 days spread over a period of 2 years, 11 months and 18 days before adopting the constitution. It was finally passed and accepted on November 26, 1949. And all the 284 members of the assembly signed the official copies, original of the Indian constitution. After many deliberations and some modifications over 101 plenary sessions in 114 days, the 308 members of the assembly signed 2 copies, which were final copies of the document, one each in Hindi and English, on January 24, 1950. Same day, the assembly unanimously elected Dr. Rajendra Prasad as the President of India, which came into effect on January 26, 1950, known and celebrated as the Republic Day of India. Now, the preamble to the Constitution of India. The preamble to the Constitution of India is a brief introductory statement that sets out the guiding purpose and principles of the document. The preamble can be referred to as the preface, which highlights the essence of the entire Constitution. It was adopted on 22nd January 1947 by the Constituent Assembly. The people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic and to secure to all its citizens justice, social, economic and political liberty of thought, expression, belief, faith and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact and give to ourselves this Constitution. The preamble reflects the philosophy as well as fundamental values of Indian Constitution. It dwells upon the following 4 aspects. First, it mentions that the Constitution derives its authority from the people of India. Second, it declares India to be sovereign, socialist, secular, democratic and republican country. It clarifies the objectives of the Constitution are justice, liberty, equality and fraternity. And fourth, it states the date of adoption, that is 26th of November 1949. Now we would end with the summary. After reading this module, you must have understand the concept of constitution and its relevance in running a country, the different council acts formulated before independence and their role in the formation of constitution, the Indian Independence Act of 1947, the Constituent Assembly, its constitution and functions, the Constitution of India, and the preamble to the Constitution of India and its meaning. Thank you.